5 seconds to go. Start. Thus, as per the pleadings in the earlier writ petition being CWJC number 5431 of 2008, there was no averment in support of his claim that he had annexed his NCCB certificate along with the original application. However, when subsequently the present writ petition was filed, the original writ petitioner came out with a contrary stand that he had produced all the necessary documents including the NCCB certificate along with his original application. The aforesaid is nothing but an afterthought, having failed to get any positive direction in the earlier writ petition on the ground that there is no pleading that he had annexed his NCCB certificate along with the original application, he is not entitled to any positive direction and the original writ petitioner cannot be permitted to improve his case in the subsequent litigation when it was not his case in the earlier round of litigation. At the cost of repetition, it is to be observed that in the earlier round of litigation, the learned single judge specifically observed that there is no pleading in the writ petition that the petitioner had annexed his NCCB certificate along with the original application. Once it is found that the respondent number 1 original writ petitioner did not submit the photocopy of the NCCB certificate along with the original application, which was the requirement as per the advertisement, and the cutoff date as per the advertisement was 22nd February 2004, and he produced the same after the physical test on 15th January 2007. The appointing authority rightly held that he shall not be entitled to additional 5 marks of NCCB certificate, though in the select list dated 8 September 2007 he was awarded 17 marks, which included 5 additional marks of NCCB certificate. The appointing authority disagreed with the same on the ground that as photocopy of the NCCB certificate was not produced along with his application form, which was the requirement as per the advertisement, he shall not be entitled to 5 additional marks of NCCB certificate. Therefore, when a decision was taken on the representation made by the respondent number 1 original writ petitioner, which was pursuant to the earlier order passed by the learned single judge in writ petition being CWJC number 5431 of 2008, the authority rightly refused to allot award 5 additional marks of NCCB certificate. As per the settled proposition of law, a candidate applicant has to comply with all the conditions eligibility criteria as per the advertisement before the cutoff date mentioned therein unless extended by the recruiting authority. Also, only those documents which are submitted along with the application form which are required to be submitted as per the advertisement have to be considered. Therefore, when the respondent number 1 original writ petitioner did not produce the photocopy of the NCCB certificate along with the original application as per the advertisement, and the same was submitted after a period of 3 years from the cutoff date, and that too after the physical test. He was not entitled to the additional 5 marks of the NCCB certificate. In these circumstances, the division bench of the High Court has erred in directing the appellants to appoint the respondent number 1 original writ petitioner on the post of constable, considering the select list dated 8 September 2007 and allotting 5 additional marks of NCCB certificate. In view of the above and for the reasons stated above, the present appeal succeeds. The impugned judgment and order passed by the division bench of the High Court is hereby quashed and set aside, and judgment and order passed by the learned single judge dismissing the writ petition is restored. In the facts and circumstances of the case, there shall be no order as to cause. Stop.